In this episode of the Cole Memo, I sit down with legal professionals to discuss
the Illinois Supreme Court has ruled for a second time on a consolidated case involving traffic searches and the smell of cannabis.
We'll explore what this Illinois Supreme Court decision means and its broader implications. From WCIA 3, here's the ACLU's reaction to this case.
There's no way to prove after the fact what the police officers smelled other than the police officers say so. So then you have the police officer's word against the driver's word or the passenger's word. And there's really no way to hold police officers accountable to be accurate in those assessments.
And here's the response from the Illinois Association of Chiefs of Police.
Well, they are kind of in conflict, obviously, but we understand the reason why it's in conflict.
Kenny Winslow is the executive director of the Illinois Association of Chiefs of Police. He says raw and burnt marijuana smell different from one another, and through training and experience, officers have learned to tell the difference.
We just have to, rely on our experience, rely on the guidance that the courts have provided and move forward.
Towards the end of this episode, we'll briefly discuss the hot topic of hemp. As always, you can find links to most of the content we reference in the show notes. Enjoy the episode. Thanks again for sitting down with me, both of you. Before we get into the episode, I wanted to remind my listeners of a few things. My mini documentary, which features cameos from today's guests, is now available for free. You can stream it free at colememo.com/minidoc. It's just 59 minutes and it encapsulates years of my work and distills my key contentions with Illinois cannabis policy into a bottle. I also want to remind you all that this show is made possible by listeners like you. You can support the show by giving it a positive rating on whichever streaming platform you're listening to this from, sharing it with your friends, or by visiting colememo.com/support. If you're not watching this episode on Patreon, you're watching it a little bit later than our patrons. For just $3 a month, you can become a patron and get early access to new episodes. That's at colememo.com/Patreon. That's colememo.com/PATREON. Lastly, I'll be taking a holiday break soon, so our feed may be a little bit quieter until I return. Evan, Bob, welcome back to the show. Evan, we'll start with you. Can you remind my audience who you are and what you do?
Thanks, Cole. I'm Evan Bruno. I'm a criminal defense lawyer at Bruno Law Offices with locations in Urbana and Bloomington, Illinois.
Thank you. And Attorney Galholtra. Bob, how's it going? Welcome back. Please remind the audience who you are and what you do.
Hi, Cole. Hi, Evan. I'm Bob Galholtra. I'm an attorney in Chicago. I've been an attorney for 34 years. Practicing in the courtrooms here in Cook County, and then for the last 5 years after retiring from the public defender's office and a lot of other counties throughout the state. I also, Evan's very humble. He hasn't mentioned that he is the chair of the cannabis law section of the Illinois State Bar Association, of which I'm a committee member. So, Evan is, of course, one of the leaders in this field. And it's a very, very interesting set of circumstances we find ourselves in.
Yeah, absolutely. Absolutely. And I want to get into the most recent ruling. But before I do that, I first of all just wanted to thank you both for making yourself available to come on the show, for clearing. You've done a lot to clear up my understanding of the cannabis law, and I get feedback from my listeners all the time. So I just wanted to thank you for doing that. I'll have some of the former episodes we've done together pasted in the show notes. To start our show today, I wanted to have a brief recap on the legal background on both of these cases. So before we talk about the latest ruling, I just wanted to ask, how did we get here?
It's interesting because the two leading cases now within the last few months, Molina and Redmond, both give a pretty nice historical background of the evolving law in Illinois. Unfortunately, it hasn't evolved as it has in some other states. And what I mean by that is initially cannabis was illegal. There were some programs available where if you were convicted of an offense, you could get supervision, which maybe could get expunged from your record, et cetera. And it wouldn't, be a mark on your record if you completed the program and things like that. Then there came a period of time where there was the compassionate use of cannabis, and therefore it was not only allowed with a medical card, so to speak, but there was also a decriminalization, which is not the same as legalization. Those are two different terms. So decriminalization would mean, yeah, you know what, you had the cannabis, but we're not going to charge you with a misdemeanor. What we're going to do is we're going to fine you. So it was a finable offense. Uh, it was not necessarily legalized. But then, as we know, January 1st, 2020, um, the General Assembly enacted to change the Cannabis Control Act, and the Cannabis Regulation and Tax Act was promulgated, which then created this whole system where people could legally obtain and possess cannabis and cannabis products, but only a certain amount. And you had to be a certain age, and the amount differs whether you are an out-of-state resident or an in-state resident. But having said all that, it still remains illegal to transport cannabis across state lines. That's still a big problem. And that's really, I think, what's driving, so for lack of a better word, that's really what's driving, I think, some of the in this area, because you have an interstate and you have cannabis available in other parts of the state and in other parts of the country and not in other parts. And there is this sort of transportation that's taking place. And you have state troopers and other law enforcement officials who are very interested in seizing that and identifying, arresting those individuals, seizing the plants and drugs, the cannabis, and also vehicles sometimes for forfeiture. So that's a big part of what the Illinois State Police and other law enforcement agencies are involved in, even though cannabis has been legalized in Illinois. There are some cases, Stout and Hill. Stout was the case that said that the smell of cannabis was probable cause. Hill was a case that, this was during the decriminalization of cannabis, but it wasn't legalized yet. And they said, yeah, we're really not going to talk about legalization yet because this case isn't really from that time. At this time it was decriminalized, et cetera. The bottom line is it always had to do with and still has, a totality of the circumstances. That's the test used to determine whether or not there's probable cause to search a motor vehicle without a warrant. And those searches and whether or not there's probable cause, the issue is if you can smell cannabis, right, and cannabis is legal, then what's the crime that's being committed here? So there were two cases. There was the Molina case and there was the Redmond case. And both of them were joined together for oral argument in January of this year. The first case, Redmond, is one involving sort of a downstate case where a car is pulled over and there's no impairment, but the license plate's a little, ajar. It's hanging on one bolt, I think, and the car is maybe speeding 3 miles over the limit. So they get pulled over, and the officer smells the smell of burnt cannabis and therefore engages in a search. There's some questioning of the defendant, but under the totality of the circumstances, the court finds that, based on these facts, just because you smelled cannabis is enough to go searching the car, even though what you found was cannabis in raw form that this person was charged with in a possession of cannabis case. The other case, Molina, was decided actually as a motion. These were motions to suppress. So that motion to suppress was granted in Redmond. In Molina, the motion to suppress was also granted, incidentally, the same trial judge. And in Molina, you had a passenger, kind of interesting, a passenger who's in a vehicle that's pulled over for speeding. The passenger window goes down. The officer smells cannabis. and he smells the smell of raw cannabis, even though he initially testified that it was burnt cannabis. And then he looks at his police report and goes, "Oh yeah, yeah. What I meant was raw cannabis." And I've been trained to tell the difference between raw and burnt, and there's raw cannabis here, and so therefore I'm going to do a search. They search, they find some marijuana cigarettes in the console, they find some cannabis um, in a container in the glove compartment, and the passenger who says, "Hey, this is my stuff. I got a medical card. What's the big deal?" They go, "Hey, you don't have it in a properly um, you don't have it in an odor-proof container as required by the Illinois Vehicle Code. That cannabis must be transported in an odor-proof container. So we're going to charge you." So the case goes to court, and the judge grants the defense's motion to suppress, saying you can't search this because it's just the smell of cannabis and it's legal now. So there were some interesting arguments made, but the appellate court in Molina did not agree with the trial judge. The appellate court reversed the trial judge and said, "No, you shouldn't be granting this motion to suppress statements. Motion to suppress evidence, because the law says that it has to be in an odor-proof container." And we looked at the law, and the law was written at the same time other laws go into effect. So we're not gonna tell the legislature of how we want to interpret this. We're gonna read it the way they wrote it, and the way they wrote it, it's still illegal. So it's still illegal to possess cannabis in certain quantities by certain people in certain places. Okay, so that's the holding that Justice Steigman came up with in Molina, the appellate court. So now, like I said, January, they joined these cases for oral argument. Both those defense lawyers who did both of those cases argued to the Supreme Court. Justices asked questions, and they come back with a decision initially in September on Redmond saying, burnt cannabis, the smell of that's not enough. And then recently, earlier in December, in Molina, saying, the law is the law. The way it's written, it's got to be in an odor-proof container. We're not going to change the law. The legislature, they're the ones who write it. They could change it. We see that they were trying to change it, and if they're going to change it, they should maybe think about working on both laws so it's completely clear to everybody. But hey, hands off. We're going to kick this we're gonna kick this over to the General Assembly because it's on them.
Yeah. And Evan, anything to color in on that?
Bob covered it really well, and that's all totally accurate. If he's the play-by-play, I'll do the kind of color commentary on the point he just made about the history. This law, I should say, these laws suck in terms of a legislative draftsman standpoint. This would be like if a contractor got hired to build a new house and there was a dirty old shack sitting on the property, and the contractor said, "We need to build a new house, but let's not move the shack. Let's kind of build this house on top of it, leave it there, and maybe we can put the footings, on top of the shack." And so instead of just starting from scratch, the legislature, when it legalized cannabis, did not repeal any laws. They just built this new set of laws on top of it and essentially said, here are the pathways you can snake your way down to avoid falling into the old law. But as this case, the Molina case, illustrates, it doesn't really work, because even in this case, the Supreme Court basically said, yeah, this is inconsistent. There's part of the law that says it's legal to possess, for people over 21, to possess, consume, and transport cannabis, notwithstanding anything else in the law. It's legal to do that. But actually, there is this separate law that says that you can't transport it unless you do it in a certain way. And so even the new laws that they built are internally inconsistent. They don't agree with each other smoothly. And so add on top of all that the fact that, we've got everything's built over this criminal regime. It's just a huge mess. That's legislative lawmaking in Illinois for you, I guess. But hopefully the legislature takes this invitation from the Supreme Court and goes back to the drawing board in large part. I mean, they're not going to do some huge overhaul. I don't think that's too much to ask, but they need to go back and find points of ambiguity and disagreement amongst all of the current cannabis laws and sweep away some of the stuff or clarify it or get it all to agree with each other.
I mean, I always think back to how this problem had been identified years ago, the odor-proof container requirement, because in this space, the cannabis space, most people understand that cannabis reeks, even if it's in a container sometimes. Definitely anybody and we've talked about this, anybody who goes to dispensary, the odor of cannabis or the aroma of legality is completely everywhere, right? It's hard to think that you can have cannabis that is going to be in an odor-proof container. It just doesn't seem possible. And so there were steps that were taken by the various state representatives and also Senator Ventura to try to remove this language from the statute. The problem is, because of the timing of the Illinois Supreme Court's opinion in Molina, this really can't be addressed until next year, which means 2025. And the General Assembly has to. I think you need a 3/5 majority in both houses in order to have it immediately effective. So let's say the first law they're going to address is the odor-proof language, which I doubt there's going to be that much energy to do that or that much motivation. The earliest that it's probably going to take effect, if they do address it, is in June, when most of these laws will go into effect if they're passed in the spring session, assuming the governor signs it.
Yeah, and I want to talk about that, but just a quick thing I wanted to color in. Correct me if I'm wrong on this one, Evan, but you taught me that, and I think this is, well, before I get to that point, Evan, Bob, you mentioned that it smells in dispensaries. Everybody who's been to a dispensary knows that when you go in, it smells like cannabis. And the reason that's an important point for those that don't know, in Illinois, all product arrives prepackaged. So some people have this idea that like, oh, they're putting the weed in the jars in the back room. No. It comes in that packaging, it stays in that packaging, and the reason you can smell that packaging is because it's not odor-proof, meaning that the moment you purchase and get into your car, you're out of compliance with the law.
And so no, you had another point. Go ahead. We'll come back to
that. You brought up the point that that's a new law, Evan. That's what I wanted you to correct me if I'm wrong on. That was created with the CRTA. In other words, before that, the time period that Attorney Galholtra was referencing, if I got caught driving with a joint in my front pocket, which I'm not recommending that we should be able to do that, I'm just using it as an example. In the past, during that decriminalization period, that was just a ticketable offense. I'm on my way. Yeah. But it wasn't a Class A misdemeanor with up to a year in prison. And so that's one of the things I believe you've taught me. Was I correct on that, Evan?
Yeah, that was a compromise. The state police and the sheriff's association, basically the cop lobby, said to the legislators, we're going to push back on all this. If you legalize cannabis, it's going to take away our ability to search cars based on the odor of cannabis. And so the compromise was, they say, well, let's take what we can get and just say that it's a new law that, to go along with legalization, it has to be in an odor-proof container. And that way we'll still be able to search cars on the basis of the odor of cannabis, but it's still, legal. And so that was kind of slipped in there. I'd be surprised if more than a handful of lawmakers who voted on that really knew about that odor-proof container rule and that it was in there. But I've heard this straight from the horse's mouth. This is the head of the Illinois Sheriff's Association who told me this in a moment of candor, that the reason why that odor-proof language is in there is specifically so that they can search cars based on the odor of cannabis. It is literally a law that's only purpose is served if it's being broken. It's a law that requires motorists to conceal from law enforcement during a traffic stop the odor of potential contraband, the odor of an intoxicant, the odor of marijuana. And if you give it more than a second thought, you think, well, why would they ever? What would ever possibly be the reason why police would want you to conceal that odor from them at traffic stops? And obviously it's because they don't. They want to be able to smell it and say you're violating the container rule, so we're going to search. And I would challenge anybody who exists in this state to give me a counterfactual or a counter argument to that.
Right. It'd be great. And I don't want you to forget your point, Evan. So please, if you don't have it already written, write it down. But it'd be great if the state gave us some advice. What is an odor-proof container? Right. And I actually have one over here that the Illinois Department of HHS may have made. It's the point though, is I've interviewed canine officers, police officers, just in general. I want to be clear. I did not interview a dog. I interviewed a police officer that could handle a canine unit. And they've all admitted to me, even some that have worked on the border, by the way, they've all admitted to me that there's no such thing as an odor-proof container. And if there was, canines would be ineffective. I wanted to make 2 points about the odor-proof container, but Evan, I wanted to give you space. You had a point.
You might be going where I was going. I don't know.
Yeah, we'll see. Go ahead.
In Molina, I don't have the exact site in here, but I found it interesting that the Supreme Court said in Molina, it's on paragraph 58. They point out that these stringent odor-proof container requirements of the vehicle code, the only other place in Illinois law where it cites the odor-proof container requirement is as it applies to the packaging of cannabis for sale, so dispensaries. And the Supreme Court says these recreational users, they must abide by the same stringent odor-proof standards that the dispensaries have to abide by, essentially. That last sentence right there. And so what I hope happens, not because I'm a narc or I want to get anyone in trouble, but if we really want to see movement on this odor-proof container ridiculousness, if we want to see the legislature do anything about it, one of the 102 elected state's attorneys in the state of Illinois needs to prosecute a dispensary for selling cannabis that's not in an odor-proof container, because every dispensary in the state of Illinois is violating that law that applies to them. It says you have to package it in an odor-proof container. And so everyone who's feeling the pain of this ridiculous odor-proof container rule, they're all on the downstream user end. And I imagine whether the cases have seen publicity or not, it's at least theoretically possible, probably more so after this decision, that we'll see more people getting prosecuted for having unopened packages. If you're a real gunner cop and you think marijuana is bad and you want to, do what cops do just to for the sake of charging people or arresting people, you just need to have your squad car idling in the parking lot of a dispensary, and every person that comes out, pull them over and say that you smell cannabis, and you're just going to start printing money in terms of prosecuting people and finding people. So if we really want to see some change, the flaunting of the odor-proof container requirement needs to start with holding the retailers accountable who are selling people packaged cannabis that violates the law on the container requirement.
Yeah, and one of the things you taught me to that point, and I'll play a clip that was actually made on the House debate for the Cannabis Regulation Tax Act on May 31st, 2019, was that you made the point that this only applies to private vehicles, which I was just like, am I correct in remembering that? Like, in other words, if it is a dispensary vehicle and they get pulled over, since that's not a private vehicle, they can't call them on that, in other words.
Did I say that?
Maybe
Yeah,
on our last podcast. Yeah,
I
I think so.
sometimes forget facts that I've once known. But, yeah, I mean, it might be somewhere.
Yeah, I think there's different regulation for transporters. I think transporters have sort of immunity on that kind of stuff, is my understanding.
I think, yeah, they just have to have a manifest. And I think the point you made, Evan, on the recent podcast we did was that it's in the vehicle code, which only
Right. Yes. Yes.
applied to private. Yeah. So, hey, wanted to play this clip because, sometimes I think people are asking themselves, what were the lawmakers thinking when they made this a part of the law? Well, before it became law, somebody asked that exact question. Let's watch a quick clip. Get it playing now.
Test for the level or just the presence? Because those are two important distinctions.
They are fully operational at the Springfield lab.
Here it is.
Let's discuss the use of drug detection dogs. Currently, most, if not all, of the drug detection dogs in Illinois are trained to test for the presence of marijuana. If they alert on a vehicle, that gives the police officer probable cause to search the vehicle. If this becomes law, do you believe that a dog alert for drugs on a vehicle will still be constitutionally valid?
Yes, these dogs can still be used. If a dog indicates on cannabis, we do believe that it'll be probable cause for the officer to conduct a search or extend a Terry stop. We're not changing any laws on what constitutes probable cause or reasonable suspicion. If the dog's indication can be used as probable cause or reasonable suspicion today, it can be used after this bill passes.
So, sometimes people ask, did they intend to do this? I think that's an indication that perhaps that was the intent of writing that part of the law,
There's, and I'll let Bob speak on this. Just my brief thought is there are a lot of things that the late Justice Antonin Scalia said that I disagree with, but I absolutely disagree with his hatred of using legislative history in judicial review. When a court says, well, how do we interpret the statute? Let's see what the lawmakers said on the floor of the House when they were voting on it. That is all just everything that woman said. I'm sure she's good at what she does. That's all just nonsense. She's basically saying we are going to bind the courts to if a dog is printed to detect cannabis and it hits on a vehicle and the person gets arrested for something and his defense attorney says cannabis is legal, the dog hit is invalid. That woman standing answering questions in the floor of the Capitol building has no say over that. It's a meaningless statement. I don't know if Bob.
Yeah, I think that was Senator Kelly Cassidy, and I think those kinds of things were maybe not the most thoughtful things to have said, because I think those kinds of statements provided reassurances to a lot of legislators to okay the law and to support it. I think it was meant more to provide support than really explain and provide a guideline for courts. They're the last people who need direction from the General Assembly with respect to what they were thinking. That's not to say that in legislative construction or in determining what the intent of the legislature was, you don't look at those things. But when things are written as they are in the case of the Cannabis Control Act and the Regulation and Tax Act and the Vehicle Code, it's there in black and white. It's really not very the statutory interpretation is pretty straightforward. And so it really I guess my frustration is that we're going to be 5 years into this legalization of cannabis, and the consumer still has no clear direction on what should happen. A lot of people are still unclear about the transportation odor-proof container requirement in vehicles. And I think it's really incumbent upon the General Assembly to do something about it. And that means that consumers, that means that the millions of items that have been sold at dispensaries this year, those folks who purchase those millions of items should really reach out to their legislators and tell them to do something about the odor-proof language. That's really, I think it's more of an organizing effort at this point, because I think the courts are not going to go any further with this analysis of what the Illinois law is. It's not going to be, we're not going to, it's not a dream situation where all of a sudden now we're going to follow Colorado or something like that. And then, Kelly Cassidy's her statement regarding dogs and the police dogs. The state police already, I think, is on record saying they're training dogs now not to be imprinted with cannabis detection because they want to avoid this situation, as other states have. So I think they still have some dogs now that have come out of training that are not imprinted to search for cannabis. But based on the Supreme Court case in Molina, they may start imprinting them again.
I actually believe you're correct. I'm pulling up a report that the Illinois State Police just made this year. It's the part of the annual cannabis report, and I'll get it pulled up here in just a moment. While I pull that up, I want to play one other clip that I think will get us right, keep us on track while I search for this reference. This is convenient timing to play a clip. So the background on this clip is, first of all, kudos to Evan again, being humble. Evan, correct me if I'm wrong here, but you were instrumental in introducing language that would have addressed this issue. And like Attorney Galholtra said, Senator Ventura, I believe, took it up, or maybe it was Senator Lightfoot. I can't remember exactly. But the point is, that language actually was just rescinded. We briefly discussed it. We briefly discussed this during our last meeting. Let's watch the clip where the Illinois Sheriff's Association opposes that language that you drafted, Evan.
Thank you, Peter. I'm going to invite the opposition up. Jim Kychuk from Illinois Sheriffs.
Thank you, members of the committee, Madam Chair. Jim Kychuk on behalf of the Illinois Sheriff's Association. Really, our issue is pretty simple. It's on page 325. It's at the very end of the bill, and it's regarding the elimination of the odorless container. My understanding, though, and I don't want to speak out of turn here, but there is going to be a change to that will be reinserted. If that's correct? And that would remove our opposition.
Would that remove the opposition of the chiefs of police and everybody else?
Yes, ma'am.
Okay. And Leader Lightford, you will be making that amendment?
Yes, it was an oversight.
Sounds good. And I'm assuming that amendment would go straight to the floor?
That's the goal.
Thank you.
And so right now it's just struck. We'll just add it back.
Thank you. With that, I will open it up for discussion.
Right. So any thoughts on that? I'm almost to the point where I can share the report I was just referring to. I mean,
I wouldn't call it an oversight. I mean, I think it was pretty calculated. I think it was serious horse trading with the Sheriff's Association. In that Molina opinion, if you look at footnote 7 on page 17, that sort of tells the whole story of what was going on in the General Assembly. We are mindful of pending legislation where, one, the Senate has proposed an amendment to the vehicle code that would provide, quote, the odor of burnt or raw cannabis in a motor vehicle by itself shall not constitute probable cause for the search of a motor vehicle or person. And that was Senate Bill 125, introduced by Senator Ventura. And then 2, there were a couple of House bills, too. One of them was the House has proposed an amendment eliminating the odor-proof container requirement from the vehicle code, House Bill 1206. That's the one that Evan was instrumental in advancing. I think Curtis Tarver was the representative who introduced that bill. I know the Tarver bill is a dead bill. I think Ventura's bill was okay going into the fall veto session, but obviously that's over.
So this had to be, might have been March of 23. I went and testified at that same table that you just showed in that clip. My proposal that I submitted sometime in 2022 was, here's the amendment. just copy paste the text of the vehicle code and draw a strike through of the word odor proof. That was the only thing I suggested.
Yep.
At some point, Senator Ventura, who is really a good advocate in this area, added that second part that says the odor of burnt or raw cannabis alone will not be probable cause to search a vehicle. With all respect to what Senator Ventura was doing, I didn't like that because that's complicating things. So it's all about striking that word odor proof. And if the word odor proof had been stricken and they had changed that law a year ago, this whole Molina case would not exist. There's nothing to talk about if that word is stricken through. The problem, so if you were to not strike through the word odor proof, but then you were to add what's in footnote 7, the odor of raw or burnt cannabis alone shall not be probable cause, then a cop can smell the odor of raw cannabis and he can say, well, I smelled the odor of raw cannabis and the person seemed suspicious, or I observed something else. It still would be a crime to have cannabis not in an odor proof container. So saying that the odor of raw or burnt cannabis is not probable cause is like a fix. You're trying to fix something where the breakage is not. What's broken is that the law requires an odor-proof container. And instead of plugging that hole, you're like putting a Band-Aid over it. You can just eliminate it. Just eliminate the odor-proof container requirement. That's the simplest thing to do. And if you do that, then all of these extra little considerations kind of fall away. So
yeah, it becomes almost like a tautology. Any quote unquote odor proof container emits odor, so therefore you can search whatever vehicle you come up to.
Yeah. And then if you say, well, the odor of raw cannabis alone isn't enough, then it is like a paradox. It's illegal to have a cannabis not in an odor proof container, but violating the odor proof requirement of that law is not probable cause. It'd be like if there was a law that said you're not allowed to possess guns or ammunition. It's illegal. And then someone passed a law that said possessing ammunition is not illegal. It's like, well, we'll just eliminate it from the other law. You don't need to add another law. Just eliminate it from the first law and you're good. So this is like the whole cannabis regulation system in Illinois is all these kind of weird little patches. It's a mess.
Yeah. Yeah. And there really is no, I think, and a couple of the dissenting judges, I think, are of the same opinion, this distinction between burnt and raw. It's just such an artificial kind of distinction. And, I'm not so sold on this idea that a law enforcement officer can really tell the difference between the two. Because if you see it in practice, in the Redmond case, they thought it was burnt, but they found raw.
Right. Oh, I've been a cannabis user for half my life, and I could still be fooled in the right situation. And also, burnt cannabis. What a very old school concept. Probably, I don't know most cannabis, but I'd say most people who have used cannabis in Illinois since legalization, I don't know the empirical data on this, but I'm sure a lot of them have taken gummies or they've vaped it from a vaporizer pen. And so you just get into these weird, antiquated ways of looking at things. And this is why back when these cases were first consolidated and we watched the oral argument in January, I said, they're going to screw this up. They're going to screw this up somehow. I don't want to go off your agenda, Cole, but
go ahead. I've got the ISP thing pulled up, so go ahead.
Here, Bob, one of the things that I've been lamenting in this Molina case is that, the trial judge, to his credit, said, well, people might smell like cannabis just from being around it. Maybe they work at a cultivation center. There's other ways that the officer could have smelled cannabis other than it being in the car, in a improper container. And one of the things I think I'm sure you and I have talked about is, it would have been great if they had made a record call in someone to testify, maybe an expert, doesn't need to be like a scientist, but just maybe someone who works at a dispensary, just get some data in the record, some information in the record. Now, after Molina, if there was a motion, if you had a case where a guy had been stopped and searched for, and the officer said it's just based on the odor of my detection of raw cannabis, would it even be proper for the judge to hear from an expert that, well, look, all of this dispensary packaging, none of it's odor proof, and look, my guy works at a cultivation center, that's why he smelled it. I think if you're the judge there, you say that's irrelevant because the Supreme Court has said that the odor of raw cannabis alone is enough. So I don't even want to hear that other evidence. It's irrelevant. I think that's the case now. Whereas the first go around, maybe it would have been a different story. I mean, you always have the good faith exception too. So
yeah, unless you craft some sort of maybe necessity defense that, it's just not possible to have it in an odor-proof container.
But that doesn't get you around the good faith exception.
Yeah.
The officer's just going based on what the Supreme Court said. The Supreme Court said right here, the odor of raw cannabis alone is probable cause. So you might be right that the rule is unfair, but the cop can't be blamed for following the Supreme Court law.
Well, no one's trying to file a 1983 civil rights action against an officer for arresting somebody based on this. The idea is to get the stuff suppressed so that you're not convicted of a possession offense or a illegal transportation offense. But having said that, there's a very simple solution. It's House Bill 1206. It was as clear as day, and the General Assembly missed the opportunity. They gave the opportunity to the Supreme Court, and the Supreme Court has basically thrown it back at the legislature saying, well, the way you guys wrote this, it means what it says, which is it's got to be in an odor-proof container.
And now the cops are going to go, and Cole is going to segue into what I think you have pulled up, but they're going to start imprinting their dogs for cannabis again. And now in 2025, when some lawmaker says, let's strike this odor-proof rule, the state police are going to say, whoa, well, we just went through all this trouble to re-imprint our dogs for cannabis. So, we're going to object to this.
There we go.
So
That's
for our listeners, this is from a cannabis annual report. This is in the Illinois State Police section. I'll have it linked in the show notes so that you can view it yourself. There's a section on page 55 that says, since January 1st, Illinois State Police does not imprint new ISP canines with the odor of cannabis. ISP continues to monitor court rulings on whether cannabis imprinted canines may be sufficient to justify a probable cause search of a vehicle. If court rulings are in favor of cannabis imprinted canines, the odor of cannabis could be imprinted quickly and easily onto existing canines that are not already imprinted with cannabis at little to no cost.
I wonder how expensive deprinting is.
Well, that's what's funny is I was just about to bring this up. People can Google the headline. I don't know if you remember this, but I believe it was Keep Cannabis Illegal or We'll Kill the Dog. And it's from Washington. The Washington Post originally reported it. Apparently, Chad Larner, who was a cannabis trainer. Here's 3 different articles talking about what I am referencing. On 2018, an Illinois police officer, look at Chad Larner. Yeah, he basically said that dogs would have to be euthanized in order to, it would amount to too much abuse on the dogs. Oh, it was actually Howard Buffett, who, by the way, is Warren Buffett's son. The biggest thing for law enforcement is you're going to have to replace all of your dogs. And then they reference later in the story, a canine trainer suggests some or most will have to be euthanized. That was the Chad Larner I was referring to. Again, Google that, folks. You can read it yourself. To your point, Evan.
Cannabis trafficking is a very lucrative thing, not just for the cannabis traffickers, but also for the state police. I mean, it's a big hit when you arrest somebody with more than 5,000 grams of cannabis. Anytime you do that, it's a super X. You've got forfeiture at play. If there's any cash, it's going to be taken. The vehicle's probably going to be taken if you own it. I mean, there's a huge slew of consequences to violating the Cannabis Control Act with respect to large quantities, and that's exactly what the state police is trying to interdict and trying to capture. That's it. That's what, and they need the smell of cannabis to do that.
And the number of people where the smell of cannabis gets the cops into the car to search, the people whose ultimate big charge is cannabis related might be less than half. There's also the guns they can find if they find cocaine, heroin, fentanyl, meth. Not that those aren't serious issues. And I think the state police and the sheriff's association would say, see, you're proving our point. We need to be able to get into cars to search because we find all these guns. It might be true. But the odor of cannabis isn't lucrative just because it leads to cannabis. It's lucrative because it's a key to get into the car where they can find all sorts of stuff. I mean, they'll tell you human trafficking, fentanyl, nuclear weapons,
terrorists, whatever. Yeah. Don't forget, when a car's going by on the highway at 65 miles an hour, you can't smell the cannabis. There has to be a reason to stop it. Sometimes the reasons are even innocuous, like, hey, we're just trying to help you out. You had a little taillight that was out. By the way, why don't you come into my vehicle so I can write you a warning? And then that's when sort of hey, guess what? Before you know it, you're being asked questions that are designed to understand what your activities have been, and also to allow what they call a free air sniff, where in the meantime, they're calling up a backup officer to come with a dog to run it around the vehicle to see if they can find probable cause. Right. So, I mean, that's typically the presentation. And the real, for example, the ACLU, right? Their big beef with something like this is the folks that are getting pulled over are black and brown. And when they're pulled over, the percentage of those black and brown people who actually you're going to get a hit off of, who are actually carrying this stuff, who are arrestable, is much lower than, let's say, Caucasians who get pulled over. The incidence of the percentage of the Caucasians actually having illegal amounts is far greater than black and brown. So that's why the ACLU doesn't like laws like this, is because they allow police to target certain individuals just by the way they look for no real reason, for no real reasonable reason.
Yeah. And thank you for getting into and explaining how there's a profit motive for the police, because some people don't exactly understand that. And if to put it in a bottle, it sounds like they can seize your property and then auction it, or even the cash you may have on you. Is that the profit motive?
Well, I mean, those are forfeiture laws, and with the forfeiture laws, my understanding is the state police gets 50% of it.
65.
Or 65. Okay.
Where does the other percent go?
It's in the statute.
Oh,
yeah.
Where does the other percent go? Where's the rest of the money go?
Like the clerk's office
okay.
and local government, that kind of stuff. But the sheriffs, the troopers themselves or the state police get 65%.
And keep in mind, Cole. So if you have, say, someone's pulled over in Douglas County, and the officer smells raw cannabis, searches the car and finds a gram of cannabis that's in a Ziploc bag, or maybe it's in some kind of container, but it's not odor proof. And the state's attorney's office charges them for the violation of the vehicle code for the container. And that's the only thing they're charged with. They're not charged with trafficking or guns or serious drugs. They're just charged with violating the container rule. It's a Class A misdemeanor. My understanding is, I think the latest generic assessment for a generic misdemeanor, this is written in the Illinois Code. If you're found guilty of that offense, just the wrong container, there's an assessment, not even a fine, of I think $1,381 or something. That's just the mandatory assessment. Then the state's attorney's office can also tack on a fine, which could be up to $2,500. Usually, maybe they'll give you a break and only give you $500 worth of a fine. And then if you go on, say 12 months of court supervision, which is a slap on the wrist type of offense, That's $25 a month for a court supervision fee, which comes out to $600. Am I doing my math right?
300
$300
or six for a year.
$300 for a year, $600 for 12 months. So there's a ton of money that they'll suck out of you once they smell the odor of cannabis in your car. It's not just forfeiting the car, although that's the primary motivation, I think, for maybe the state police or the sheriff.
Yeah. Well, and no offense to attorneys because you do all good work, but another element of this, one of my friends got arrested and charged with this crime. People, if you want to see it, you can go to colememo.com/isitlegal. One of the things that I found interesting was as soon as he was charged with this crime, thanks, Bob, he got a bunch of mailers from attorneys, like people knew. And again, I'm not saying that. I appreciate the work that all of you do. But I thought that was interesting. It's like, oh, if people are sending you mailers, like that's a part of the profit. Like people are making money there too, you know, like you don't just send mailers out. Right.
Yeah. The brethren of criminal defense attorneys is I don't see any criminal defense attorneys writing their legislators to keep the laws harsh, even though maybe maybe it'd be in our financial interest. I think Bob and I,
right, I agree. Yeah,
and I know you're not accusing him of that. I think it's kind of an ethos where maybe it's in our business interest for people to be getting arrested all the time, but I think we have a different ethos. It's more about not having people get screwed over. That's more ingrained.
Yeah, and I've made sure to that's one of the questions I've asked you both in the past. Like, if this is something you're having to deal with all the time, why are you trying to solve the problem? And you're like, well, it's just wrong, well, hey, Bob, I know you got to get going soon. Evan, if you're able to hang on for a sec to talk about hemp, that'd be awesome. If not, that's okay. I wanted to quickly round out our conversation while I've got you both. What do you think are the immediate implications of this ruling? Do you think, especially with regard to law enforcement? I mean, law enforcement themselves, we just read their own report. They say they're going to start retraining canines. Do you think people should be a little bit more on edge until this issue, or careful rather, until this issue is resolved? Like, what is your, vague legal advice for people that might be listening and might find themselves in this situation? Tread lightly.
Yeah, I'd say tread lightly. Put the stuff in the car trunk. Don't have it in your immediately accessible anywhere, and don't think that it's a green light to be smoking weed in the car because it's burnt.
Thank you.
I would not do that because then you're going to have all sorts of impairment issues, and you're still going to be violating the law. In Redmond, there was no evidence that the defendant himself had been smoking cannabis.
Yeah, some people had jokingly written in, if I smoke in my car, does that protect me since the smell of burnt cannabis isn't allowed to be searched for? And you're shaking your head no, Bob.
No.
So yeah, don't do that. Evan, any thoughts on immediate implications?
I frankly think that all the news coverage kind of has probably been exhausted. I don't know, like the local news stations, WGN, I don't know how much of an appetite they have for now a new update after Redmond came down in September to now do an update on Molina and try to parse out the difference. So this might just get buried.
Do you think it gives, here's a last question before you go, Bob and Evan, either one of you can weigh in on this one. Do you think this gives, do you think any law enforcement officers saw this and they're like, let's go, I'm going to start saying that I smell raw cannabis so that I can get into people's car?
Yeah, I mean, how do you ever really test what it smelled like?
Right?
I mean, there's no way to count. It's not like you walk up with a meter and it's like, oh, look, the smell is so strong. Mm-hmm. It's just basically the testimony and credibility of an officer. And I think most judges have accepted officers who testify and say, I know I've been trained on the difference between raw and burnt, so it's a very, I think this is really going to embolden the police to continue doing the searches the way that they have been. And I think that the consumer, I think what the action they should take is to contact their legislators to remove that odor-proof language. That's really the way forward.
Yeah.
That's the only way forward. Yeah. 100% agree.
Yeah. And, just a little humor before you go, Bob. as Evan said, we've been studying this for years. And somebody could still fool me on the smell between burnt and raw cannabis,
Yeah.
right? So it's kind of crazy.
If consumers switch to cartridges, vape cartridges, I think that does eliminate a lot of the odor issue.
Sure.
Which may be an adaptation that some people will wind up taking. You see somebody, vaping, you don't know what they're vaping. You have no idea unless you actually seize it and test it. And so, that may be a safer method for people if they're going to consume cannabis.
Yeah, it is interesting to think about the fact that edible cannabis is like one of the most popular growing trends, categories, whatever, and it is arguably not a part of this at all. I in other words, I think most like people that are trying it, kind of curious, like they're riding around with edibles, but
yeah, we only talk about edibles when we talk about emergency rooms and children, or like elementary schools and like kids having to go to the hospital. That's when we talk about gummies.
Well, Bob, I know you got to drop off,
thanks so much, Cole. Appreciate it.
Yeah,
Evan,
absolutely.
I'll see you next week at the annual meeting or the mid-year meeting.
Thursday.
2
days.
Take it easy. Take it easy. Bye-bye.
And Evan, you free to hang out for a little conversation on hemp before you go?
Sure. You're the hemp expert, though. I usually defer to you when I'm wondering what the rules are.
Right. And mine is more about actually something, my perspective, my question on this is more about like something you had taught me in the past on one of the first podcasts we ever did together, but just some background for folks. I've been consuming cannabis for more than 10 years. And the reason I love, and I'm doing this with air quotes, hemp is because it's afforded me more access to the cannabis plant than any state legal marijuana program. And what I mean by that is, unlike state regulated systems, hemp is unfettered by arbitrary restrictions like purchase limits, possession limits, and for the most part, dosage caps. And in the past, when I've asked why it seems every state insists on having arbitrary restrictions like purchase or possession limits, I've been told that these restrictions were added due to the scheduling of the cannabis plant and the existence of a legal document, which this show is named after, the Cole Memo. In other words, it seems like these restrictions are based on the idea that cannabis is a Schedule I drug that must be heavily regulated. And so, like, again, just for brief background for people that don't know maybe as much about this subject as you and I do, all the products we're about to briefly discuss, because I don't think this will be a terribly long discussion, are derived from the same botanical plant, Cannabis sativa. But I'm going to introduce two legal terms, right? In other words, these are not based in science, they're based in law. Hemp, as defined by the 2018 Farm Bill, which is cannabis containing less than 0.3% Delta-9 THC on a dry weight. And I'll display a graphic in a moment for people that just said, what the fuck does that mean? And then you've got marijuana, which is cannabis with more than that 0.3% threshold. And it's usually regulated under state laws like the Illinois Cannabis Regulation and Tax Act, but it's still federally legal as a Schedule I substance. So I just said that marijuana is still federally legal as a Schedule I substance. Quick fact check on myself. What I meant to say was that it's still federally illegal and it's categorized as a Schedule I substance. Back to the show. So I'll show the image the graphic I was just referring to explain what hemp is for those that are listening. This is a good graphic that kind of breaks it down. The language has been extrapolated to mean that any hemp product with less than 0.3% THC by weight is in fact legal hemp. So this is a gummy with, a portion of the gummy containing THC and most of the rest of the gummy containing gelatin, sugar, and cornstarch. That's kind of how you can fit that definition. So as I lead up to my question, the United States, I don't know if you know this, Evan, recently began the process of rescheduling cannabis under the direction of Joe Biden, which is a really awesome, like one of the biggest steps we've ever taken with cannabis. But many advocates and activists argue that we should be fully descheduling, not rescheduling, basically pointing out that if alcohol and tobacco are descheduled substances, cannabis should be as well, right? And to wrap around to my question, in the past, the Illinois Cannabis Regulation Oversight Officer, and we've discussed this in the past on the show, has mentioned some cases where law enforcement either pulled over individuals for hemp possession or encountered storefronts selling hemp but were unable to act. I even recently interviewed the owner of a smoke shop, and I'll display some footage here in a second while we chat, where law enforcement seized approximately 40 pounds of legal cannabis hemp flower. And just to get to my question, you had taught me that the CRTA begins with this statement. In the interest of allowing law enforcement to focus on violent and property crime, the General Assembly finds and declares that the use of cannabis should be legal for persons 21 years of age or older. I skipped over some words, but the emphasis on in the interest of allowing law enforcement to focus on violent and property crime. So with that being arguably the spirit of the law, it's the first few words from the law. And then you have the Cannabis Regulation Oversight Officer saying, and other people in the cannabis industry saying that law enforcement needs the ability to go in and act, right, and crack down. It's like, my question is, do you think that that conflicts with the spirit of the law, giving law enforcement that ability to act on nonviolent cannabis offenses?
If the goal of the legislature was to free up police resources so they didn't have to focus on enforcing cannabis laws, they would have repealed one fucking cannabis law. They didn't repeal a single criminal law concerning cannabis. So it's all kind of nonsense speak. I mean, if my honest opinion on it is, I don't really give that any weight in terms of what it actually means. It sounds nice, but the spirit of the law is for all of the people who helped pass it to get reelected. Like every law, I'm not trying to be cynical towards Illinois, but it's all to kind of, for the most part, to help re-election and to do what's popular and what's going to satisfy your constituents. And a component of that is trying to get more revenue for the state. So that's where the tax comes in. And there's probably a lot of lawmakers who say, I want to get reelected. I know that most of my constituents, if asked, would say, yeah, people shouldn't go to jail for small amounts of cannabis. It shouldn't be a crime to have cannabis in a non-odor proof container. They probably would know that about their constituents, but they'd also know that, look, if the Sheriff's Association endorses my opponent, that's not going to go well for me either. So it's just a constant balancing of interest, tugging and pulling at different ends. And the Sheriff's Association and the state police said, we are not going to go along with this unless you insert these things that we want. I think you kind of asked a broad question about the spirit.
Yeah.
I don't know if that was directly on hemp or if you're talking about just the spirit of.
Well, it's like, right. It's like this idea, and I'll play some footage while we're talking. Like, here's law enforcement taking these products from this smoke shop that ended up, we're about to see footage of them returning it because they found it was hemp. And it's like, they're wasting our time and tax dollars. Here's
yeah.
And yeah, I was just like, as people call, and here he is returning the cash, to the business, and here they are returning the product. And I won't play it right now, but one of the police officers says, this feels weird, like they're bringing drugs back, to the place. My question really was like,
good for them, honestly. I mean, bad for them for caring in the first place, but I guess good on them for admitting their mistake.
Yeah. I guess like when I heard try to put my question in a bottle, when I heard the Cannabis Regulation Oversight Officer basically saying, we've been talking to the state's attorney's office to see what can be done. I'm like, you just described a scenario in which people aren't getting arrested for cannabis. What are you talking about? Anything needs to be done. That sounds like success.
So he was saying that we're not arresting people, and that's a problem.
Correct.
So here's where it gets complicated, because it's an agency by agency thing. I would bet that maybe the Chicago Police Department is cool with this. They probably have more pressing stuff to do than go around trying to interdict cannabis. I think the Champaign City Police Department is probably similar to that. We have shootings here, gun offenses, and I have seen probably a significant drop off in just pure cannabis possession or distribution cases. But you move 30 minutes south to some small town, smaller county, where they don't have shootings, they don't have big gun crimes, but they have a sheriff's department, they have local police forces. They probably don't want the legislature to take cannabis off their plate. That gives them something to do. It gives them crimes to charge. It gives them searches to execute and vehicles to seize. The video footage you played of the guy's hemp getting seized, there are probably plenty of police agencies or officers or sheriff's deputies who would see that and say, what are these guys doing? What do they care? It's I don't want to paint the entire law enforcement community of Illinois as one homogenous single mind.
Yeah,
but the fact that there are cops that say we haven't been arresting anyone for cannabis, what can we do? Doesn't surprise me. It's pretty gross, but
my question really is about not so much. I appreciate you breaking that down, because that was an important point to make, but it's like, how do I put this? It's almost like people that are supposed to be on our team are saying this, like people that are in the cannabis business, or like I said, this is a cannabis regulator, not a law enforcement officer. Like, this person is overseeing the social equity program and everything, and they're saying this is a problem, we need to shut it down. And it's like,
you're saying with hemp specifically, or just
yes, with hemp, like they're basically what they're calling it.
I get what you're saying,
Evan, is like unlicensed. They're saying these are unlicensed operators, and it's like, well, give them a license or let them.
It's a loophole.
Yeah, that it's a loophole.
They're worried
right.
that there's some loophole. Again, I mean, I can never put myself in the mindset of someone who thinks like that. It's just antithetical to everything that I have ever believed in terms of letting people do things, letting adults do things that don't hurt other people, just live and let live. I could see how someone who's paid, invested millions of dollars in a cannabis operation being a little salty that there's guys down the street who haven't had to get a license, haven't had to get approval, don't have to get inspected, just getting people high for a profit, without having to put in all that investment. But I get it from a business standpoint why that's unfair. But from a liberty standpoint, I'm just in the box of, let's stop looking for things to make illegal. But
Yeah.
there's serious a business interest. Money is a real thing. Investing in a business is a real thing. And when the government tells you have to do this stuff if you want to sell products that get people high, and then people do all those things and invest all that money and equity in it, and then they find themselves being undercut by people who didn't do any of that, and the government kind of says, well, that's okay. There's a little bit of bait and switch there.
Right. And I get that. I totally get that element of it. I guess my thing about it is, and it's related to one of the comments you've made, but I have people on the show all the time that are actually, that have espoused these exact ideas that I'm talking about. And they've said, like, it feels unfair. And my question to them on that is like, well, what's stopping you getting involved in hemp? And they say nothing. It would just be that we've sunk all these costs into this license. And my response to that is usually like, that's literally a fallacy that I learned about in like college English, like sunk cost fallacy. Yeah.
Yeah.
I mean, I get it. I feel like if I were in their shoes, I would probably feel the same. So I want to reiterate my empathy for that position, but it's just like it's not unfair. It's like almost taxi versus Uber, you know.
I hate that you're making me take this position, but my counter argument to that is the sunk. I've always looked at the sunk cost fallacy as like this idea that we've already spent all this money, and so we should just keep doing what we're doing, even if all signs are pointing to it's not going to work out. Yeah, but the licensed growers and dispensers are competing with the hemp guys for a finite resource, which is the customers. And if the government says we have these two competitors and one of them has to spend, millions of dollars to compete and the other one can compete for free, that's unfair to me. And then I guess if you'd say then, well, why don't you just get into the hemp business? They'd say, well, we can, and we probably will have to, but it doesn't change the fact that we're now out $3 million or whatever it is to get a dispensary off the ground.
Right.
The reason we're in that position where we're out $3 million for nothing. Now we're just in the hemp space because that's, we have to be there. The reason we're out that money is because the government told us we had to. And then after they told us we had to, and we did, they're now saying, well, no, you actually didn't have to. And that's, detrimental reliance, to use the contract term. It's, it's I guess it's misleading, bait and switch, whatever you want to call it. And again, I don't really want to change that system because I like the fact that hemp is available. You can get a can of it at Binny's or at a gas station. I like that. But if I had spent a bunch of money on a dispensary, I wouldn't.
Yeah.
And
that's what it really seems to come down to. Like, to your point, it's if you've sunk all that money into it, like they don't believe that these people should just be added to the pool. But it really does. One of the other houses, you used a great analogy earlier for the house we built over the criminal law. It's like we've almost built a house also over the idea of protecting licensees against natural market forces, we're going to keep the pie limited, you know what I mean? And it's just sort of interesting. And my last thought on this, and we'll wrap up. I can't help but wonder if at a certain point when this continues to go on, and as you said, there actually are, it's crazy. A lot of the people that I've talked to that were really against hemp are getting into hemp, because they have to your point, to survive. And I start to wonder, I recently saw a lawsuit against the state of Illinois from transportation licensees. They're basically saying, I don't know if you read about this, but we had the lawyer on. I can send you the link if you're curious to hear about it. She's basically alleging that the state of Illinois, in some way or another, made the transportation licensees worthless. And I'm just wondering, if there's ever going to be a place where these licensees either sue the state of Illinois for making a false promise. Because I feel like this all speaks to the fact, and this is kind of how I started this whole conversation off with, we have overregulated the shit out of cannabis, And so to your point, those people, they're in a rough spot because they had to jump through all those hoops. But at the same time, I'm left wondering, those hoops they shouldn't have had to jump through those hoops. I'm sorry that they did,
Right.
It's a weird place we find ourselves.
Yeah. It's you can't really sue the government very easily. You definitely can't sue. You can't sue the state of Illinois as the state of Illinois. You can sue maybe, you can sue agents of it. But I don't know. I don't know if the law is changed in a way that's unfair. I think history has said you're pretty much shit out of luck. But when the automobile came about, the buggy whip manufacturers were really pissed. I'm glad that they didn't win out.
Right.
Every time there's some, and this is, I think it's the heart of what you're saying. Every time there's some innovation, someone kind of gets screwed. The Underwood typewriter company got really screwed with the word processor. The difference here is the only reason why, the Tom Howards of the world exist, the only reason why these dispensaries exist in their form is because the government said you have to exist in that form. You have to put in so much goddamn equity and money to get this operation off the ground because of the red tape we've put in place. But now we're the ones who are going to undo it. It's not like some, entrepreneurs come about and developed a new method.
Right.
The only reason why hemp is a thing and it means anything is because the government has been, stepping in and trying to, police this area. So it is a very unique situation. I'm sure there's probably some analogs in history of this from, we have a lot of bureaucracies here in the United States, but it's not just innovation. It's the government, making these people climb a mountain and then, offering free helicopter service the moment they get to the top. So
yeah,
it's tricky.
It is. And to close it out, the real, I know I said it at the beginning when we started this conversation, but I wish we could, what I've been saying is let's take the best and leave the rest on hemp, right? So I love that it dismantled all of these concepts we've been talking about on the show for years at this point, like possession limits, right? The fact that it just completely, there's no possession limit on hemp. I can have a truck full, basically. I mean, obviously, as you've described in the past, if I get pulled over by law enforcement, you're not going to beat the ride. You're not going to win that debate on the side of the road oftentimes, but just conceptually, that's really my point. And that's why I'm so obsessed with this topic is I feel like in many ways there are wins. Like you said, you can get it through traditional retail channels, or I got some delivered to my door earlier today. And I just wish that in our cannabis policy, we could take all those good things and leave all of the rest, because there are some, I think, accurate critiques of some actors using like synthetic chemicals and everything to create some of these products. And yeah, that should probably require, some oversight. I think any good operator also is willing to, subject themselves to that. But yeah, that's why I am obsessed with it and always bring it up with both you and Bob, because I feel like a lot of the things that I frankly kind of critique Illinois about, hemp has delivered on, at a federal level.
Yeah.
So, well, hey, we covered a lot of ground today. We went a little bit longer than we had planned. So I just want to give you the final word. Any other thoughts before we go, Evan?
Yeah, on the hemp issue, it's just everything we've talked about I'd feel screwed if I had invested a lot of money in this. The reason why that argument can't win is because the only way it wins is if the government makes more stuff illegal. The government says, okay, well, the only way to be fair to you is we're just going to have to regulate hemp, the way we regulate everything else. And that's not the right way to do it.
Yeah.
So the government's not going to fix this. They're only going to make it worse. I should say new laws aren't going to fix this. They're only going to make it worse. We got enough law. We need to start chopping away at it or trimming it back. So
yeah.
Hopefully that happens.
It's interesting. I recently read somebody in the Tribune say exactly what you just said. They said, I'm against prohibition. I don't think it works, and it causes more unintended problems than it solves. Very well put. All right, Evan. Well, thank you for joining me to break down the latest ruling. Again, thanks to Bob, even though he's not with us. And folks, I hope you found as much value in this conversation as I did. See you on the next episode of the Cole Memo. Take care.
Hey, Cole. Thanks.